Good morning, everybody. It's Madelena Viksne from Samfiru, Tumarkin. I'm an employment lawyer at the firm. I thought I would start off today speaking about the recent amendments to the occupational health and safety regulations in British Columbia. Um, so these new regulations are going to prevent employers from reassigning tasks that were refused by one worker to another without pretty clear disclosure about why it was refused by the first one, to sort of ensure the safety of the entire workplace as opposed to just those who are sort of cognizant of those concerns in the start. So under the OHSR, if an employee refuses a task because of safety concerns, the company has to address those issues before the work can be reassigned to somebody else. And if it remains unresolved, the employers now have to inform staff who are now going to take on the work that was previously refused by another employee, excuse me, um, what was refused and why the job was turned down by the previous worker. And the notification has to be actually provided in writing, which is good because it sort of provides confirmation and clarity as to what the concerns were, and gives the employee proof that it did or did not happen. And they have to provide the specific reasons that the employee felt the other job was unsafe, and why the company believes the task doesn't create an undue hazard. Employers in BC can't force you to perform work that you feel is unsafe. It's illegal, and if they threaten or punish you for asserting your workplace rights, that's also illegal. It's called reprisal. So if your employer does that, you should contact an employment lawyer, such as those at our firm, to discuss sort of what your options are moving forward. I wouldn't necessarily recommend that you immediately resign from your position. In BC, if you resign and you're non-unionized, you typically don't receive severance because it's considered voluntarily quitting your job. So the purpose of contacting us as soon as there is an issue like this would be to ensure that whatever has happened is sufficient to afford you rights to severance, and understand what your risks are moving forward and pursuing, the potential for a constructive dismissal. However, you should certainly contact. The first step for any employee is to raise the issue with their employer, and explain why they feel that the workplace is unsafe, why they feel that there are concerns that need to be addressed, and what you need to sort of have addressed prior to it being something that you would consider a safe, hazard-free workplace. And if there is no resolution, then at that point it's necessary to sort of consider what your next steps might be. Keeping records is going to be really important. Records of the workplace, if you are able to and want to take photos of whatever the hazard is that you saw, that's a good idea for the purposes of ensuring that your employer has a full understanding of what the issue is, especially if it's been sort of cleaned up, so to speak, since you observed it. Another important thing to do would just to be taking, excuse me, stumbling today, to be taking contemporaneous notes. One way to do this that I usually recommend is to email yourself at the time or just shortly after the time that you've observed something. The email has a timestamp, and so it's a little bit more certain than just writing notes yourself that you sort of write a date on. It's much harder to refute. Keeping records is going to be important in the event that it is something where we feel that a constructive termination could be established, because we're going to need to be able to demonstrate that the employer took steps that were in breach of your employment contract. In this case, it would be taking steps that put you in an unsafe work environment, which under any employment agreement whether written or not, you have a right to work in a safe and hazard-free work environment. I have a question from Taylor on YouTube, who's asking, is it normal for your boss to give an employment contract when you're brought back from a layoff? Um, I mean, it's normal. I guess I'm going to rephrase that question. You don't have to sign anything that you receive from an employer after you've already been working for them, unless there is an agreement and a new contract made, which would include offer acceptance consideration. Um, the offer would be whatever the contract is, acceptance would be you saying yes, and consideration would be what you receive in exchange for your agreement to those new terms. The most important thing to note here is that you are not required at various different points throughout your employment to just randomly sign a new employment contract. Um, you you have established terms of employment. If your employer would like you to sign new terms, especially after a layoff, those are likely going to be more restrictive than your previous terms were. For example, if you didn't have a provision in your contract that allowed your employer to lay you off um, previously, it's very likely that if you're getting a new contract after a layoff, that it's sort of intended to avoid the ability of you to claim a constructive termination in the event that there is a termination, that there is a layoff at a later point. We are seeing a lot of contracts being put out now that have provisions regarding layoffs. I'm sorry, my voice is not great today. I apologize. Um, and because of that, I think that you need to be very cognizant of what this new contract entails. It may be sort of preempted with something like a raise per hour or an extra week of vacation. That would be considered the consideration that you're receiving in exchange for giving up those additional rights. However, um, it is a really good idea to speak to an employment lawyer before you even consider signing it, so that we can explain what is new or different between your old contract and your new one. This is particularly key in the event that you didn't have a written contract prior to the layoff. Um, Sort of the main point, I suppose, obviously, an employment contract lays out all of the terms of your employment, but one of the main points of having one um, is to is to restrict your employment entitlements to only those either in the contract or under the statute. If you have them in a contract or under a statute, um, then then it's restricted to only those amounts. If you didn't have any employment contract prior to the layoff and now they're asking you to sign one, I guarantee you, almost no such thing as a guarantee, but I guarantee that they are trying to restrict your rights on termination to less than what you had before, and or implement new terms that protect the company and don't protect you. So understanding what it is that you're signing in like a more fulsome way than you might be able to without the assistance of a lawyer is really, really important. So never sign anything in the room, and don't sign anything until you've spoken to counsel. It's just very unlikely that it's going to be for your benefit, and much more likely that it's going to be for the benefit of the company, and that you may not understand exactly what restrictions you are placing on yourself. Um, Sorry, also back to Taylor, it is not uncommon that we're seeing this. So US isn't normal. It's not uncommon. That doesn't mean that it's something that you should necessarily just go along with. But it's not sort of totally out of left field, if that makes sense. So Elliot has asked from Facebook, I've had to take substantial time off due to long COVID. I'm being told by coworkers that a manager is looking to fire me due to absenteeism. Can they do this? So this is a bit of a specific question. So it sort of depends on what you mean by taking substantial time off. Have you taken a short-term disability leave or long-term disability leave? So multiple weeks at a time, wherein you're receiving either EI sick benefits or you are receiving your long-term or short-term disability coverage, and therefore on a medical leave. Or are you meaning that you have sort of taken more time off than you normally would have, sporadic sick days, a week here, then back to work for 2 weeks, then a week there, day there? Um, in terms of a claim for absenteeism, it's likely not having to do with your disability leave rights. However, it's hard for me to say that without knowing more. Elliot, I would suggest that you speak to someone in our office if this is something that either you're concerned about in terms of your specific circumstances, or something that um, you feel may be discrimination on the basis of disability. Um, I think also, long COVID is becoming a more and more established thing, and a more and more established sort of avenue to absenteeism or illness at work, um, as more people are sort of diagnosed with it or it's better understood. So I would say that you likely would have the ability, or at least should consider the possibility of taking a disability leave in the event that you believe that it's necessary and your doctor would support it. Um, the reason being that it often helps the employer, if there is sort of a consistency or some sort of a potential future timeline for return, as opposed to sort of sporadic absences. There's also more protections for you, generally speaking, in the event that you have a doctor's note that explains everything. If you haven't provided your employer, with a note from your doctor that confirms that this is something that's going on, um, I would suggest that you go and you get one. Once you have disclosed to your employer that you have a medical um, disability. Now, when I use the word disabled or disability, what it means in the law is just something medical that is preventing your full engagement. It doesn't necessarily mean that it's a disability in sort of the colloquial sense. But that said, I would suggest that if you haven't provided a medical note to your doctor, that you get one. One thing to note is that your employer is not entitled to know the diagnosis that you have or any medications that you're on, um, save for if you're in a safety sensitive position, which would require you to be operating heavy machinery and your medications don't allow that. If that's the case, then I would say, um, they're only entitled to the absolute bare minimum amount of information about your diagnosis, medications, and so on that is required for them to make a informed decision about whether it's safe for you to continue to operate in your position. But most generally speaking, they are not entitled to a diagnosis. All that your medical note needs to say is that your doctor has advised that you're not able to work at this time. Um, you can, due to health conditions, you continue to be under their care, and you will continue to be under their care until such time as you're reevaluated and found to be able to return to work. If you provide a note like that to your employer, it's going to be much more difficult for them to terminate you for absenteeism or otherwise, because you have protections under the Human Rights Code, wherein you taking time off for a medical condition would potentially be illegal on their side. If they were to punish you, complicate things, it's called reprisal, as I mentioned earlier, similar to the workplace safety stuff. Um, if you are punished essentially for enforcing your legal rights in employment. Um, so, you take time off and then you're suspended, or your hours are cut, or so on. That's a breach of their obligations under the statute. So, JR asked, what is one way to find out the results of an unemployment claim investigation despite being in contact with the DOL and filing weekly certs? This has been over a month without benefits. We don't really deal with unemployment. Uh, Service Canada is who you should be contacting, assuming that you're Canadian. Um, it sounds from the language you're using that it's possible that you're American, and in that case, I can't advise. However, if you're having issues with unemployment, it's not uncommon for it to take more than a month. You will get back pay with benefits. So if your claim should have started on August 5th and you still haven't heard and eventually are approved, um, you don't lose the 6 weeks or whatever it is that you were waiting for. The answer, you'll get that amount as well, in most cases at least. But Service Canada is who you should be contacting. Um, and the only way to get any information about it is to call them and sit on hold. It's an extremely long and arduous process. It certainly is not easy or streamlined, from what I hear from my clients. But unfortunately, I don't have anything other than that to tell you. Service Canada sort of manages that type of thing. Cyber August from YouTube asked, what if they insist that you sign a contract favorable to them and only give you the job under these circumstances and not as an employee, and then decide after 3 years to let you go with no cause? If they're insisting that you sign a contract, you've accepted the contract if you decide to sign it. I'm not sure what you mean by insisting. If you were offered a position and they wouldn't negotiate the contract with you, they're not technically, before you're employed, required to negotiate the contract with you. I mean, likely it's in their best interest to do so, but realistically, they're offering you something and your acceptance is what it is. You can negotiate, but your acceptance is on the terms of the agreement that you've signed. Um, and you have to remember that in most cases, you're talking about a business. So obviously, the terms are going to be favorable to the business needs of the company, as opposed to you. For you, that's what the employment standards are there for. They're there intending to ensure that at minimum you receive certain things, especially when there is a unequal bargaining power between employer and employee. If you're ever offered a contract, you can always call our office and have that reviewed before you sign it. And that's usually a pretty good idea to have a contract review. Even if it means that you put out a couple $100s, it's a good idea to have it reviewed by a lawyer, whether it's our office or elsewhere, um, and have sort of the terms that maybe are not as straightforward and clear explained to you in some more detail so that you're understanding exactly what it is you're signing, exactly what rights you're sort of limiting yourself to, and what sort of maybe will be the case in certain circumstances that could come up along the way. For example, what are your rights for sick days, or when does your vacation entitlement increase, or even understanding ways that you can approach the potential employer for the purposes of negotiation. Those are all things that you can get from any lawyer that you speak to. Um, if they said they would only give you the job under those circumstances, then that's their offer. And you deciding to take the job and work the job likely amounts to acceptance. Um, if they're refusing to, if they're calling you not an employee, I would again speak to counsel, especially if you've now been terminated. Um, the reason being that there is a lot of confusion over what is properly going to qualify at law as an independent contractor and what is going to qualify as an employee. There were some changes in the legislation over the last while, trying to make it more specific that you're not able, um, that they don't have the same employment obligations to you as they would if you were an employee. Um, but there's also a number of companies that have generally used the idea of an independent contractor improperly. And so the legislation changes have tried to sort of rein that in a little bit. But if you were terminated, certainly you should speak to somebody. And yes, you're correct. Dependent contractor and independent contractor are two different things. A dependent contractor effectively has the same rights as an employee in most cases. So certainly you should be speaking to counsel. Carol from YouTube has asked, if you leave a job due to harassment, are you owed any compensation? Well, everybody is entitled to a workplace free from harassment and bullying. I do want to stipulate, however, that the meaning of harassment in terms of the colloquial sense, what feels like harassment to you as an individual, what could be perceived as harassment by those around you, is not always necessarily the same thing as what constitutes legal harassment. So, in order for you to have a legal right, it would have to reach a certain threshold, and that higher threshold is something that could be determined by counsel should you speak with them. In terms of whether if you've already left your job, it may be somewhat more complicated. It really depends on what your it really depends on how you left the job, and whether or not you had made the company aware of the issues prior to your departure. And if not, why not? Maybe the person that you are being harassed by is the person that you would have reported it to. But generally speaking, you should have had to report it to them before. Something should have had to be done. If nothing was done, that's one point. If it was investigated and nothing was found, but you still feel like it's the same or the behaviors didn't change, that could also be another point. Um, but as I said, it is going to depend on your specific fact circumstances in terms of whether or not there's going to be the possibility of you pursuing something like a constructive termination. Generally speaking, to pursue a constructive termination for the purposes under the issue of there having been harassment, it certainly is going to have to be something that was known or reported to the company prior to your departure. And if you haven't left yet, I would suggest speaking to counsel before you try to do so, because I think it's very important that you understand how to build a record. Um, a lot of harassment cases end up being sort of he said, she said issues. Um, and because of that, it can be very difficult to prove that what you're saying you experienced actually happened without something like contemporaneous emails to yourself outlining sort of the back and forth between you and, for example, this manager who's treating you poorly. It's also can be really difficult to um, ensure that you are protecting yourself in the moment. And there are steps that you can take to sort of limit your contact with this person while it is that you're building a record, or well, you maybe haven't quite reached that level of harassment, but there are sort of ways that you could report it and see if it could be investigated and try and go from there. Um, it's very fact specific. So, Carol, I would suggest that you speak to somebody in our office and see whether, your circumstances make sense in terms of supporting a constructive termination, whether it's the way in which you resigned, or the disclosure that's already happened with the employer, or whether, there's been an investigation and so on. So that's all for today. You can join us at other times this week for additional live streams with members of our office. The next one is Wednesday with my colleague Jeremy Herman. And if you have any further questions, you can ask him then. Have a nice day, everyone.